All right, good afternoon. I'm Judge Steinley. This is Division 2 of the Coconino County Superior Court. We're on the record in CR 2023-00379. This is State of Arizona versus Adam Woodwise Smith. At the outset, I am going to read the Victim's Rights Advisory. If you are the victim of a crime with a case pending before this court, you're advised that you have rights to justice and due process under Arizona law that, among others, include the right to be treated with fairness, respect, and dignity, to a speedy trial, and to a prompt and final conclusion of the case. You have a right to be present at court proceedings, to choose whether or not to be interviewed by the defendant or the defendant's attorney, to be heard before the court makes a decision on release, negotiation of a plea, scheduling and sentencing, and to receive restitution from a person who's been convicted of causing your loss. If you've not already been provided with a written statement of all victims' rights, you may contact the Victim Services Division of the Prosecutor's Office to obtain one. So with that, I'll turn it over to the attorneys to put your appearances on the record.
Good afternoon, Your Honor. Daniel Noble for the state.
Good afternoon, Your Honor. Joe Tobler for Mr. Smith.
All right, and just for the record, Mr. Smith is present in person here in the courtroom. I'll also just note the court I did have my assistant contact the Legal Defender's Office. I want to thank Mr. Carver for coming over with no notice here this afternoon. The court in this case has received the motion to withdraw filed by defense counsel in this case, Mr. Tobler. I have not granted that yet at this point because I did want to have, at the very least, have you appear in court here today for some clarification for the purposes of the court and also potentially for the Legal Defender's Office. At this time, the status of this case right now is we're in the middle, essentially, of a contested Rule 11 competency hearing. The court had previously heard from a single mental health expert. Dr. Linsky has testified previously up to this point. Today had been the time that the court had scheduled to hear from Dr. Pardee and then also from Dr. General, who was a doctor retained by the defense to do a Rule 11 evaluation after funds were granted to the defense for that purpose or going forward. The court has not received any unredacted or redacted evaluation from the defense. So the court, before you're withdrawn from the case, Mr. Tobler, I want to know what's the status of that process because the court has not seen anything.
Yes, Your Honor. Being as Dr. General was a defense expert, we spoke with him about his findings. We found them not to be helpful to our defense, and so we elected not to have an opinion written by him as we didn't think that would be beneficial to Mr. Smith. So at this time, Dr. General has done an evaluation, but we are electing not to call him as a witness and not to have him write a report.
All right. Did you have anything that you wanted to raise, Mr. Noble?
And that was the one question I had, so thank you, Your Honor. I don't have anything else.
All right. So then where we are in the case right now is the court has the motion to withdraw, which the court has considered. The court doesn't expect to have Mr. Tobler place anything more on the record than what was placed in the motion to withdraw. The court at this time is going to grant the motion to withdraw. For the proceedings and the stage where we are now, the court is going to appoint counsel to represent Mr. Smith at least.
Objection. I do not consent to the withdrawal, and I do not consent to the assignment of Mr. Carver.
And I know that, Mr. Smith, it's noted that you don't consent to that. I'm only at this time appointing counsel during the Rule 11 process. I don't know that it'll be Mr. Carver.
Objection. According to the Mental Health Handbook, I am not eligible for Rule 11, and according to State Ex Rel Mitchell v. Wine 255 Aries 313, in the penalty phase, the state may not compel a defendant to submit to a mental health evaluation. Thank you.
But the court is appointing the Legal Defender's Office, Mr. Carver, for at least the Rule Rule 11 proceedings, the court has no confidence that Mr. Smith is competent to represent
And I have no
himself
confidence in you. You are in violation of the 14th Amendment of the United States Constitution and concordant provisions of the Constitution of the State of Arizona, Joshua Steinlage. You have been asked, both in a writ of mandamus as well as in a separate 10.1 motion, to recuse yourself of this case. There is a conflict of interest. You have represented Donald Leacock, who is the co-defendant of Howard Seth Leventhal. In 2008, both convicted child rapists. You have managed to get them favorable outcomes to be released after a single day in the Department of Corrections. And Rachel Bieliski organizes child sex parties in the form of Gnostic Catholic Mass for the terrorist organization, the Ordo Templi Orientis. You have a conflict of interest, and I do not consent to these Rule 11 proceedings. I affirm and I attest that I am competent to stand trial for the alleged attempted murder and kidnapping of Rachel Ann Bieliski, date of birth, 31st of March, 1982. And I demand a speedy trial. I demand a public trial. I demand a fair trial. And I demand a trial by jury of my peers. And with regards to the victims' rights, what about Rachel Bieliski's victims of mass murder at North Area Health Services, where she murdered people with homicidal hospital protocols without even a medical license? Do those victims have rights? Joshua Steinlage.
So, Mr. Carver, the court is appointing the legal defender's office. I realize it's a difficult stage in the case.
I will be taking this up with the Supreme Court of the United States, Joshua Steinlage. Do you understand?
And then we will reset the matter as soon as a attorney can be appointed to Mr. Smith.
There will be no appointment of attorney. I am the attorney of fact in this matter, Joshua Steinlage.
And I have to convey this information to Mr. Carver, Mr. Smith. If you can't hold yourself and your comments in while I'm just trying to provide this information to the legal defender,
your opinion is irrelevant, Joshua Steinlage. You have been asked to recuse yourself, and I have asked for a different judge in this matter. You did not bother to rule either on the subpoena for the cellular provider information, which was clearly exculpatory and exonerating in nature, and you failed to rule on the 10.1 motion to recuse yourself of this matter because of the conflicts of interest. And you failed to declare for the record that you were not a Freemason nor a member of the Ordo Templi Orientis that you gave different names to, such as the Knights Templar.
So, Mr. Carver, do you have any questions or about where we are in the case? I thought it would be best to have somebody come over from your office, so because we're in the middle of Rule 11 proceedings right now. Today was supposed to be the conclusion of the contested Rule 11, and we've heard from one doctor, and we're scheduled to hear from a second doctor. Both of the Rule 11 evaluations that we have up to this point, the most recent ones, I should say, both opine that Mr. Smith is not competent but likely restorable. That's where we are.
I am not in need of restoration. I am perfectly competent to stand trial. I am able to understand the proceedings perfectly well, and we have already managed to show that there is a corrupt behavior here. First of all, Dr. Krizlinski as well as Dr. Pardee have both previously found me to be competent. Can you please explain to me, Joshua Steinlage, how does someone catch schizoassociative disorder, delusions? How does someone catch bipolar disorder whilst locked in a jail? It is impossible. I do not have any of these conditions. This is medical misdiagnosis in violation of ARS 12-542. And also, Rachel Bieliski is in violation of ARS 32-1666, practicing nursing without a valid medical license. May I please issue a bench warrant for the arrest of Rachel Ann Bieliski and for murder, mass murder, violations of the Nuremberg Code, violations of the Code of Medical Ethics, organising child sex parties with the Little St. James Epstein Island Temple cult, the Ordo Templi Orientis, that you've decided is the Knights Templar, even though the Knights Templar have been burnt at the stake more than 600 years ago.
Mr. Carver?
Judge, thank you for inviting me over. I'm glad I was able to attend to have a good understanding of where we are procedurally. I understand the court's difficulty in proceeding where it appears as though Mr. Smith wishes to represent himself, but competency is...
Objection. You do not represent yourself. You present yourself for the record. I do not require representation.
So, my understanding of the court's ruling is that the legal defender's office assigned counsel while the Rule 11 proceedings play out. When Mr. Smith is determined to be competent, then this court will hold additional hearings as to whether that appointment will continue into the future, or whether Mr. Smith will assert the right to represent himself going forward.
Correct. The court would consider whether or not he was competent to could knowingly, voluntarily, and intelligently waive his right to counsel at that time. and the court would conduct that colloquy with him for that purpose.
I have another objection, that all of the council are members of the BAR, British Accreditation Registry, and all the members of the council have said to Todd Callender that your client is going to die in my client's hospital and there's nothing you can do about it. My defence rests upon proving that Rachel Poliski knowingly and willfully murdered patients at North Area Health Services, 3700 West State Road 89A, from between about the dates of around April 2020 up until December the 15th, 2022, and that this is a state-sponsored and state-orchestrated mass murder campaign where there has been a cover-up. And Dr. Pardy and Dr. Linsky's assertion that I'm delusional is based upon the fact that the internet has been systematically censored, evidenced by Missouri v. Biden 83 F48 350, where clearly that anything to do with vaccine hesitancy or deep state paedophilia, such as the Hunter Biden laptop story, has been systematically erased from the internet. Their opinion is has two conflicts of interest. One, they are trying to defend a corrupted medical industrial complex that has murdered approximately 1.2 million Americans. And they have also got a conflict of interest because if they find me competent, they are then themselves implicated for pushing homicidal hospital protocols and gene-altering nasal PCR tests that were given peer-reviewed status in under 24 hours by Christian Drosten, which is mathematically impossible. Furthermore, apple juice, papaya, monkey urine have all tested positive for COVID-19, a mythical disease, and people have been murdered by the use of remdesivir, Veklury, deprivation of water, deprivation of food, switching off their life support machines. You are knowingly and willfully covering up a mass murder campaign. Joshua Steinlaggy, do you understand what you are doing? May God have mercy on your soul.
Anything further, Mr. Carver?
Judge, I just wanted to note that before, I believe Mr. Tobler was on the case, prior retained counsel had moved to withdraw. In between that withdrawal.
Judge, can Mr. Carver move closer to the microphone? I can't hear what he's saying.
Sure.
I object to the approach of Joseph Carver.
I apologize. I was trying to project. What I was trying to
This
note
man
is
does
that
not represent me in any way, shape, or
that
form whatsoever. I do not consent to this man's appointment as counsel.
I'm going to just ask the officers to remove Mr. Smith from the microphone because we just can't conduct the hearing with his constant inability to follow just the normal structure of hearing from one person at a time. Go ahead, Mr. Carver.
I'm just was trying to. I was just trying to report to the court my understanding of the series of attorneys that Mr. Smith has had. And so maybe if I just started from the beginning, Mr. Smith was originally represented by the Public Defender's Office. The
Correct.
Public Defender's Office withdrew to a conflict. The Legal Defender's Office then represented Mr. Smith. During that representation, he retained counsel. That, as I recall, was Adam Zickerman, a local attorney. After several months, Mr. Zickerman filed a motion to withdraw, and the court granted that motion. At a hearing between counsels, I filed a motion to have the court admonish Mr. Smith that basically dilatory conduct could result in the waiver of counsel, even if he never requested to represent himself. The point of the motion is that the court has to advise the defendant of that possibility before they can actually waive it by conduct. In any event, the court, I believe on its own motion, instituted Rule 11 proceedings at that very hearing. And it sounds like those proceedings are ongoing. The Legal Defender's Office appointed counsel per the court's order once the court ordered the Rule 11. But then the defendant or his family retained Mr. Tobler. Now Mr. Tobler is moving to withdraw for what appears to be the same reasons that Mr. Zickerman withdrew from the case. And so I just wanted to note that my motion is still out there and pending. And then so whenever the court believes that Mr. Smith is capable of receiving the message in that motion, we would ask the court to give that admonishment, basically that continued disruptive or dilatory conduct or forcing his attorneys into ethical quandaries is going to result in the waiver of counsel. Further, because he's retained two private attorneys, at least through some means, we'd ask the court, if and when it comes to the continued appointment of counsel after Rule 11, that the court conduct another indigency hearing to ensure that county resources are being spent appropriately and as necessary. But I understand the court's ruling today, or the court's requests today. We'll abide by the court's order. We'll get an attorney to ride on Mr. Smith's case while the Rule 11 is pending. And then we just ask to be involved in the council determination if and when competency is determined.
First, I'll just say, I think that your rendition of the history of counsel in the case is exactly accurate. I also recall you asking for that admonishment, but the court also, really similar to today, just couldn't conduct a hearing in any kind of meaningful way with Mr. Smith at that hearing. And the court did initiate the Rule 11 proceedings at that time, based in large part on the court's inability to conduct a hearing in any kind of meaningful way at all. And then 2 additional Rule 11s. I think since that time, since the legal defender's office was on the case in any way, 2 Rule 11 evaluations have been conducted, and both Dr. Linsky and Dr. Pardee opine that they believe that the defendant is not presently competent, but likely restorable. And we were waiting to see if a 3rd evaluation was going to be filed with the court, and the defense was going to present a 3rd view. Now we know that that isn't occurring, and I understand why. So where we are now is awaiting appointment of counsel, at least for the Rule 11 process, and then getting the second. Really, at that point, I think that the attorney, upon fresh consideration of where things are and knowledge of course, they can contact and talk to Mr. Tobler, of course, and get his view on things and the defense perspective, whether they want to continue on with the contested hearing or however they want to proceed. The court would just be interested in seeing what the newly appointed attorney's desires are in terms of picking up what we've left off, to taking that additional testimony from Dr. Pardee, or having the court make the decision based upon what we've heard from Dr. Linsky and the evaluations, or just I'll just leave that to them after they have a chance to discuss with Mr. Tobler.
Very good. I understand. Thank you, Judge.
All right. So at this point, I won't, I will set a hearing, because we have what we expect to have in terms of the evaluations, and we've already heard from one of the doctors. So I'll set an additional Rule 11 status conference. Mary, could you provide us with a possible date for that? I know it's not easy to fit in right now.
Judge, while we're
go ahead.
For a date, I would request, I'm sure that whoever jumps on the case on the defense side is going to want a transcript of the testimony of Dr. Linsky. So if I could request the court order that preparation of that transcript.
Sure.
Distribute that.
Yeah, that makes perfect sense. The court will order a transcript of the testimony of Dr. Linsky at the hearing. I believe that was on June 24th that we heard his testimony in this.
As soon as we can do a September 3rd, 1:30.
Okay.
I don't have jail time here, but.
Okay. September 3rd at 1 o'clock?
1:30.
At 1:30.
That works for the state, and I just want to let the court know. After that, I have limited availability, so the following week, but I'm available that week fairly widely.
Okay. And then, I know that you don't even know necessarily who the attorney is, but
When we assign it, we'll let them know the date and to communicate with the court if it doesn't work.
all right. All right. Thank you. Is there anything else that either of you want to address?
Nothing else from the state today.
All right. Mr. Tobler, I know that I just granted your motion to withdraw, but did you have anything else that you felt the court needs to be aware of, or anything to that effect?
Judge, I know the motion was granted, but just so that the court's aware, Since that time, new information, Mr. Smith has filed a bar complaint against me. So that was going to be a further basis if necessary, but it doesn't appear that it is.
All right, thank you. And with that, I'll just thank you again for coming over with no notice, Mr. Carver. I appreciate it. And we're adjourned. Thank you.